So I'm going to talk about some of the constitutional issues that are raised by the executive order and the challenges to the order. First, I just want to mention what might be the most central part of the challenge are the particular constitutional claims that the challengers are bringing to say that the order is unconstitutional. And the central one is that the order amounts to religious discrimination, that the order targets Muslims. Now, to be clear, the executive order doesn't use the word Muslim, doesn't say anything in its terms about excluding Muslim. It doesn't use those words at all. But the challengers in the various cases say that the policy still expresses animus against Islam and against Muslims through various means. And here's the evidence, what they point to show, or to allege, that the order amounts to religious discrimination, which could be in violation of the Equal Protection Clause or the Establishment Clause. For one thing, the order is only targeting 7 predominantly Muslim countries, and it announces that citizens of those countries alone have to go through an extreme vetting process. So just by the nature of the order, which is only applies to citizens of Muslim majority countries, is one piece of evidence for saying that it's targeting Muslims. Another thing, the order by its terms provides an exemption for refugees who are members of persecuted minority groups, which is an exemption that only applies to non-Muslims. That is, the minority religions within these countries are all non-Muslim groups. And it's a group that President Trump tweeted, or this exemption to say, is really to protect Christians. So by its terms, the policy only applies to Muslim countries and exempts non-Muslims from at least the refugee part of it. So, and in addition to the plain language in the application of the order, the challengers point to a wealth of external evidence to show that really the order is intended to and has the purpose of discriminating against Muslims. And obviously the most principal piece of evidence that they have is that Donald Trump, as a candidate, promised to institute a ban on the entry of all Muslims into the country. And then he asked his team of advisors, including Rudy Giuliani, to come up with a plan to implement that legally. And as Giuliani said, here's what they came up with. So there's a lot of external evidence, not on the 4 corners of the executive order, to suggest that the purpose was discriminatory. Now, normally in equal protection law or in Establishment Clause law, when we ask, did the government act with a discriminatory purpose? I have some of my con law students here. I wish I could call them. I would go past it. It's very disappointing. Some of my STAR students are. They could answer this question. The question is, how do we prove discriminatory intent? Do you just look on the face of the policy, or can you look to other evidence? And the courts have established, for decades, that they can look at other evidence of discrimination, extrinsic evidence to prove discriminatory purpose. And so all of these campaign statements, all of the history that led to this order would, in a normal case, be evidence to prove discrimination. In this case, the government says that there should be a different rule in the immigration context or in the national security context, so that you only look on the face of the order. Now, that was the argument that they made to the Ninth Circuit, and the Ninth Circuit didn't buy it. So the Ninth Circuit says, no, we think that it's fair game to look at all of the evidence that you presented to suggest discriminatory purpose, either for showing a violation of the Establishment Clause or the Equal Protection Clause. 2 other constitutional issues that I think, maybe 3 other issues. Another one of the claims that the challengers brought is that the policy violates the Due Process Clause, because there are people who have rights to enter the country or who have ties to the country whose rights were denied by the order without any process. People, for instance, with permanent resident status who couldn't enter the country, at least until the White House counsel's office told them that they should let them in. They had a due process claim, and the Ninth Circuit said that they had stated a claim. A third claim that they brought, now this is outside of my area, is that they have statutory claims as well. That is, the immigration statute says the president and his agents cannot discriminate on the basis of race, religion, or national origin in deciding who can enter the country. And so they say that the order violates the statutory provision. Now the president responds by saying there's another provision that authorizes the president to exclude any class of immigrants of his designation. So there's a statutory construction question between these two provisions. The other two constitutional issues I just want to mention, just so you're aware of them. First is just a question of reviewability. The government says the courts have no authority to review the executive order because the president has unreviewable discretion to decide what classes of immigrants should be excluded, and the courts have no business second-guessing that because this is a quintessentially executive decision about who's dangerous to the country or who should be excluded. And the president has some support for that claim, primarily cases that date back to the Chinese Exclusion Act of 1882, under which all Chinese persons of Chinese descent were excluded from the country, and it went up to the court, and the question was, does this violate the principle of equal protection? And the court said no, and the courts shouldn't be involved in second-guessing judgments about who should be excluded from the country, even when there's an allegation that it amounts to race discrimination. Now, those cases, of course, are from 1880s, and the question is, are they still good law now? I mean, when the courts were faced with a somewhat analogous argument in the Guantanamo cases that I was involved with, the president in those cases always said, I can decide to send these enemy combatants to Guantanamo, which is outside of the country, and because it's a purely executive decision made in time of war based on national security, and the courts have no business reviewing. And that was the issue in a series of Guantanamo cases, and the courts, you might guess, don't especially like being told that they have no business reviewing the executive decision, or being told that there's some class of cases that they can't review, that the president would have unreviewable power to, in that case, create a prison outside of the law, and the courts would have no way to judge it. Or in this case, the assertion is the president could decide to exclude all Muslims, and the courts would have no way to review that. And the Ninth Circuit, you could see from their decision, was especially unhappy about the tenor of that argument. They spent a long time citing to these Guantanamo cases saying the claim that this is unreviewable is offensive to us. That we don't have a system where the president can rule by decree and exclude a class of people without any judicial review, especially when there are allegations here that the exclusion is on the basis of religion and national origin. The third constitutional issue to mention is about standing. I'm not taking these in the order. So if I was briefing this, I would start with standing. I would start with jurisdiction, and I'd move on to merits. But I take it you don't mind that I start with the merits. For one thing, it's the more, the religious discrimination issue is the most interesting one. So I'd say, the more technical standing question for the end. But again, I'd love to call on my content students here to explain why, even some of my former students, could explain the standing issue. Here's the issue. So we have an executive order that excludes a bunch of people, some of whom have no ties to the country presently. That is, they're not in the country, they're foreigners outside of the United States. Some of them are green card holders, and some of them are people who have some connection to the United States. And the question is, does anyone have standing to argue that the executive order discriminates against them? Well, the states say that they have standing. The claims are brought by states. And the states say they have standing because they say they're injured by the executive order because they operate universities within the states, and the universities don't have the faculty and don't have the students who are being excluded by the order. So they can claim injury. The court, the Ninth Circuit agreed that that was a cognizable injury that gave rise to standing, and the states could sue. The more complicated question is, okay, so they have standing because they're injured, but they're really raising the rights of people who are not before the court. That is, they don't say they were discriminated against based on religion, the state universities weren't. They say that these other people were discriminated against because of religion, and that hurts the states through their universities. And that's a complicated question of third-party standing. This would be one that I could put on the final exam, and students would wrestle with, because that is, do the states have an interest, a sufficient interest to stand in the shoes of some people who clearly could bring the claim, like green card holders, or for the Establishment Clause claim, does any resident of the state have an Establishment Clause claim if the government is preferring one religion over the other? It's a complicated standing question, and the court sort of smushed over some of these issues in its decision, saying, sure, the states can bring the claim because they're injured, and often schools can bring claim on behalf of parents, and this is like that, and then they're done. But the issues are actually much more complicated than that. Anyway, so that's those are the set of constitutional issues that I think are most pressing in the challenges to the executive